Good morning, everyone. I'm Lynn Holtain, and it's my great pleasure to welcome you to online law talks from the Victoria Law Foundation. Today, a couple of sessions designed specifically for Units 3 and 4 of the Legal Studies curriculum. We're going to look in depth at the Victorian Law Reform Commission, and then some really critical tips on exam prep from David Thomson, our teacher in residence. First, though, before we start our formal proceedings, I acknowledge the traditional custodians of the Bunurong country where I am this morning, and also of the Wurundjeri people who are custodians of the land on which our office stands in the city, both of the Kulin Nation. I recognise their abiding connection to this land, its waterways and community, and that the lands were never ceded. It's my privilege to pay my respects to their elders and to all the generations who've nurtured this land for over 50,000 years and continue to do so. We believe at the Foundation that acknowledging the past is a very essential step in building a better, more equitable future. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of Aboriginal and Torres Strait Islander peoples. A few housekeeping tips before I introduce you to Nick, our first speaker this morning. Only the panellists can be seen and heard in this webinar because it's a webinar format. So all your cameras and microphones are switched off. Please use the chat function if you're having any technical issues to let us know about so that we can correct that as quickly as possible. And we will, of course, be sending out the slides after the webinar, so you'll receive those. No need to scribble everything down in the presentation itself. And many thanks to so many of you who've sent through questions already in advance that we've passed on to both David and Nick. But if there are any further questions that you'd like to put as you hear their presentations, just use the Q&A function and we will attempt to get to as many of those as we possibly can at the end of each session. So the way this is going to work, we'll hear initially from Nick Gadd from the VLRC, then there'll be a very short break, and then we'll have David Thomson on exam prep. So our first session this morning is looking at law reform in action, and it's about the very important work done by the Victorian Law Reform Commission, or the VLRC as it's more colloquially known. And this, of course, relates to Unit 4 of the Legal Studies course. Nick Gadd is the Communications Manager at the VLRC. He's responsible for their education program, publications, media, and their online presence. He is also, I might add, a very fine published author in his own free time, as much of that as he has. So if you see him on the bookshelves in your favourite bookshop, pick one up and buy one. Nick has been a fantastic supporter of our online law talks and our schools program in general, and I think he's schlepped all over the state presenting on the VLRC. So it's great to have you back, Nick. Thank you so much for being with us. And I will pass over to you, and then we'll have a little Q&A at the end.
Thank you, Lynn. Good morning, everybody. I hope you're all doing okay. And it's a pleasure to be here. Thank you to the Law Foundation for this invitation. It's always a pleasure to attend these events, whether in person or, as today, virtually. What I'll do this morning is we have about 35 minutes. I shall go over the basics of the VLRC, our functions, our role, and how we work. And then I'll give you a brief description of a recent inquiry that we've completed on committals. So I'm now going to share my screen. Hopefully. And hopefully you can now all see my VLRC screen. Okay. So beginning with the basics about the Victorian Law Reform Commission, and it's an independent organisation. That's really important. I'll say a bit more about that later, but it is, of course, funded by the state government. And the VLRC was actually established by this Act of Parliament, the Victorian Law Reform Commission Act 2000, and commenced operations in 2001, which means that this year we are actually celebrating our 20th anniversary of activity since the commission actually opened. But we're not able to have a party, of course, because we're all in lockdown. And the VLRC is the central agency for developing law reform in Victoria. Not the only body that's involved in law reform. There's also a parliamentary committee. There's also the Department of Justice. Law reform happens in other places too, but the VLRC is the central agency. Now we get our inquiries in two ways. Most of them, which we call references, are referred to us by the Attorney General, who is Jacqueline Symes, the Honourable Jacqueline Symes. And that is where probably 80% of our inquiries come from. They're referred to us. But we can also initiate inquiries of our own. These are somewhat different. They're called community law reform projects. And they are not referred to us by the Attorney General. They are suggested by members of the community. So they're somewhat different. And I'll say a bit more about both of those in the next few minutes. But now I'm going to talk to you about the functions of the VLRC. Now, my apologies for this rather dense slide. This is a section of the Victorian Law Reform Commission Act. Let me see if I can do that one by one. And this is an important, keeps jumping without me wanting it to. This is important because the Act specifies what our functions are. We've put the keywords there in bold for you. And the key ones that I would emphasize to everybody is examine, report, and make recommendations to the Attorney General. That's fundamentally what the job of the VLRC is: to examine the law, to write reports, and to make recommendations about how to make the law better. We have a couple of other functions as well, but I'll go through these in a bit more detail. The first of those, subsection A, is examine, report, and make recommendations to the Attorney General on any matter relating to law reform referred to the Commission by the Attorney General. So that's what I was mentioning before. The Attorney General can ask us to look at an area of law, and the VLRC then goes away, examines that area of law, writes a report, and makes recommendations about how to make the law better. An example of that is our Contempt of Court report, which we published in 2020. The Attorney General had asked us to look at contempt of court laws in Victoria. We spent a year or so examining the law, we wrote a report, we made recommendations, and we gave those recommendations to the Attorney General. Now, subsection B is the community law reform projects. Now, these are a bit different. These are relatively minor legal issues of general community concern. These are the ones that the VLRC can choose for itself. And the law says that we can't do things that are too big. They have to be matters that will not require a significant deployment of the resources available to the Commission. An example of that is the neighbourhood tree disputes inquiry. Actually, that did end up requiring a quite significant deployment because it turned out to be much bigger than we thought. But that was a community law reform project suggested by members of the community. And we completed that, I think, in 2019. Then there are these other functions of the VLRC. We have the power to suggest to the Attorney General a proposal or matter relating to law reform. And we can say to the Attorney General, hey, why don't you refer this matter to us? Of course, the final decision is up to the Attorney General, but we have the power to suggest that. We also have the role of monitoring and coordinating law reform activity, which means really just being aware of what else is going on. And E is to undertake educational programs, which is kind of one of the things I'm doing now. We do have this educational role of informing the community about law reform and about what is going on. So those 5 things are our functions, A, B, C, D, E. Students do need to be aware of all of those. There may be a question on them. Now, let's think about some of the reasons why laws may need to change. Laws may become out of date, and that may be because of society's values changing, people's attitudes changing. An example of that is same-sex relationships, of course. Now, this was not something the VLRC was involved in because this was a Commonwealth law, the Marriage Act, not a state law, but I'm just giving it to you as an example of how values change. And Victoria certainly has introduced legislation relating to same-sex relationships. The law may need to change as a result of changes in technology. This is something that often things get referred to the VLRC, which are to do with technology. If you think of all the things that can be done with mobile phones, or online fraud, data theft, sexting, things related to that, there are many areas where technology moves ahead very quickly and the law may be some way behind. So that's an area where the government may ask the VLRC to consider the law and how it should be reformed. And the contempt of court inquiry was really a good example of this, because the contempt laws were developed many hundreds of years ago, and long before there was such a thing as smartphones and social media. These days, of course, people can very easily commit contempt of court simply by using Twitter or Facebook or sharing things that they shouldn't. And so how should the law deal with that? That was something that we looked at in our contempt of court inquiry. Another reason why laws may need to change, well, there may just be some problem in the community that the law is not dealing with. And this was why we looked at the issue of neighbourhood tree disputes a few years ago. Interestingly, there's no Act of Parliament in Victoria which covers disputes between people, between neighbours about trees on private land. And yet this is a really common cause of disputes. People often have arguments about, for example, oh, your tree's too big, it's dropping branches into my garden, it's going to fall on my house. This is a real cause of concern in the community, and yet it's really not clear how people are supposed to fix these disputes. That was why the VLRC decided to take on that as a community law reform project a few years ago. Another reason why the law may need to change is it may be too complex. An example of this is the law around the instructions that a judge can give to the jury in a trial. These instructions where the judge has the job of explaining the law to the jury. Of course, in a trial, it's the job of the jury to decide the facts of the case. It's the job of the judge to explain the law to the jury. But there have been so many changes to the rules about what judges should be explaining to juries about things like evidence, that the law had become very confusing. It was resulting in many mistrials, many appeals, many verdicts being overturned. So the Attorney General a few years ago asked the VLRC to look at the law about judges in directions to juries, and we made recommendations about making them simpler and clearer. And those changes were implemented into law, which means that now a judge's directions to juries are a lot clearer and simpler. And part of the result of that is that we're getting fewer appeals and fewer verdicts overturned. So those are some of the reasons why laws may need to change. And the role of the VLRC, we don't have the power to change the law ourselves, of course. Only Parliament can change the law. The Law Reform Commission makes recommendations to the government about how the law might be changed, what we think should happen. It's up to the government then to decide, and it's up to Parliament to pass new laws if they choose to do that. But the role of the VLRC is to make these recommendations in order to make the law more up to date, to work better, to be fair, and to be more in touch with the community and community values. So fundamentally, that's what the VLRC does. And you can see it's really important that a permanent body exists in Victoria which can give this kind of advice, this kind of independent advice to the government. So we're not a political body. We don't come and go when the government changes. We're just always here giving this advice to governments. So we're independent. We're not part of the political process. If the Attorney General changes, if the government changes, it doesn't make any difference. We continue doing our work. We're a permanent body, been here for the last 20 years, hopefully be here for the next 200, we'll see. And the VLRC is, just having a bit of slide malfunction. The VLRC is an inclusive body. Now, what that means is that when we make our recommendations, we involve the community in doing that. So it's really important that the VLRC consults widely with the community. We always do a lot of consultation. We receive public submissions. We go out and we talk to people. We often do online surveys to find out what the community thinks, because it's important that the law, that people have input into how laws change, because the law affects everybody. So these three words, independent, inclusive, and the third one, innovative. The VLRC considers problems and finds new creative solutions. And when we're looking at something like the inquiry I just mentioned, contempt of court relating to social media, well, that's a very innovative area of law. So we have to be thinking of new solutions. This chap is my boss, Tony North, the Honourable Anthony North QC. He is the chair of the Victorian Law Reform Commission. There are also 9 part-time commissioners. And those 10 people, Tony and the commissioners, are the people who ultimately decide on the recommendations that are put forward in the reports. 10 people. Now, they are supported by the staff of the organisation. There's about 18 of us, and it's the job of the staff to do research, to organise consultations, and to basically draft the consultation papers, the reports, and the recommendations, which are ultimately decided on by the commissioners. So they're the people who ultimately make the decisions, and their names always appear in our reports. I'm going to say a little bit about how we actually work, not in huge detail because it would take a while, but all of this, by the way, is on our website. You'll find a diagram which shows the process by which the VLRC works. And the key things here in the early stages are, as you can see, there's initial research, there's preliminary consultations, and there's the formation of an expert panel of people who can advise us. So these are sort of some of the key things that we do. We do a lot of research, looking at what the law currently says, looking at what the law is in other places, other states, other countries. We do a lot of that. A lot of the people who work at the VLRC are very skillful researchers, legal researchers. And they're people who love research, and that's really important for the VLRC. If we're going to make recommendations, they need to be evidence-based. They also need to be based on consultations. So that's why we do a lot of talking to the community and people who are affected by laws to find out what they think. Community input is really important. So there's a whole period on every inquiry of several weeks or months where all we're doing is consulting. We're going out, well, when we are allowed to travel around the state, that's what we do. Obviously, over the last year or so, we've had to do a lot of consulting over Zoom, like everybody else. But we do an awful lot of consulting, talking to people who are affected by the law, asking them what their stories are. For example, when we did an inquiry a few years ago about medicinal cannabis, one of the reasons why people were using medicinal cannabis is because it was a painkiller, which could be helpful for people who are suffering painful conditions, sometimes terminal conditions. Medicinal cannabis could also be useful in suppressing seizures for people with certain kinds of epilepsy. But at the time, medicinal cannabis was not legal. So we consulted with people who had been using medicinal cannabis and who had been giving it to family members. At the time, it was illegal for them to do that. But they told us about what had been happening, and we had some very powerful personal testimonies from people. So that's the kind of valuable information that you can get from consultations. And we ended up recommending that medicinal cannabis should be legalized. And it was subsequently legalized in Victoria and the whole of Australia, actually, but for medicinal purposes only, I hasten to add. We were not looking at the law related to recreational use, which is illegal. So that's an example of the kind of consultations that we do. We also receive submissions, which are written statements of how people believe the law should change. So the purpose of all this consulting is to find out how people believe the law should change. And they can tell us by completing a survey, by writing a submission, or by just telling us in a consultation. But all of that is really important. We then use all that information to write a report with recommendations in it about how the law should change, which we deliver to the Attorney General. We deliver the report to the Attorney General. The whole process generally takes about 12 months from go to woe, sometimes a bit longer. We then deliver that report. The Attorney General will then table that report in Parliament. Once it's tabled, we can publish it. We can't publish it until it's been tabled. And at that point, the VLRC's work is finished. We've done. It's then up to the government to decide what they want to do, whether they choose to accept the recommendations or not, or accept some of them, but not others, or perhaps ask for further consultations or ask the Department of Justice to do some more work, or the Department of Health, whoever it is. It's up to the government. It's out of our hands at that point. But ultimately, what we hope happens is that the government agrees with us and decides on legislation and Parliament changes the law. Now, how often does that happen? I think that was one of the questions that came through. How often does the VLRC actually succeed in making recommendations that change the law? Well, we've commenced 41 inquiries since 2001. And in more than 75% of cases, recommendations have been implemented in whole or in part. Usually, I think the majority of those, the government accepted all of our recommendations. In some of them, they only accepted some of them. But at 75% of the time, at least some of the recommendations were accepted. Now, if you look at the Victorian Law Reform Commission website, there's a lot of information about this. If you look at the projects tab and then go to implementation, you'll see there's detailed information about which of our inquiries have resulted in changes to the law and which have not. And most of them have. Although it can take several years. And this is something that people don't always understand, and I probably didn't understand until I came to work for the VLRC, is that it can take years to change the law. We can make our recommendations, and then it may not be for several years that the government and Parliament actually gets around to changing it. And that, of course, gets even slower when you've got a pandemic going on, because the government is thinking about other things. So the inquiries that we completed most recently, such as committals, for example, has not yet resulted in changes to the law. I think that was another question that came in. These are the inquiries that we are working on at the moment. We are doing an inquiry about the law of stalking, and this is actually a good example of where law reform is needed to keep up to date with technology, because these days there are many ways that people can stalk each other in quite nasty ways using technology, which did not exist 10 or even 5 years ago. So we are looking at the law around stalking and we are going to report on that, an interim report by December this year, and then the final report mid next year about how the law needs to address the growing problem of stalking. And it is a big problem. Something like 14,000 cases of stalking and stalking related behavior were reported last year in Victoria. 14,000, that's a lot. So we're looking at that. We're also about to deliver to the Attorney General our report on improving the response of the justice system to sexual offences, which is going to be a really major report that is going to lead to some, we hope, very significant change about how the system deals with sex offences in Victoria. We're also currently working on a project called Inclusive Juries. This is a community law reform project which we chose for ourselves, which is about access for people who are deaf, hard of hearing, blind or have low vision to serve on juries. What do we need to do to enable people who are deaf, hard of hearing, blind or have low vision to serve on juries? A really interesting inquiry. And these are some inquiries which we have completed recently within the last 4 years. Now, I will talk a little bit, not in enormous detail because we don't have time for that. You can find more information on our website about the committals inquiry, including the final report, the submissions that we received, and the consultation paper that we published. But I'll say a bit about it now. This was an inquiry which we commenced in October 2018. We delivered our report in March 2020. So that inquiry took 18 months, and it was then tabled in Parliament late last year. Committals are the process by which serious charges for indictable offences are transferred from a lower court to a higher court. The word committal actually historically means the process by which the court officer, the magistrate, decides if the evidence is strong enough for a person to be sent for trial in a higher court. But actually the committals process involves a whole lot of other processes besides that actual decision. The pre-trial procedures which we were looking at are all the things that happen before a criminal trial. So before someone goes to trial, there are a number of hearings that happen in the lower court, the magistrate's court, where evidence is disclosed, where the issues are defined, where it's decided how the accused is going to plead, guilty or not guilty, and where matters which can be resolved are resolved. All of that tends to be referred to as the committals process, even though the actual committal is only one part of that. So we were looking at all of that. We were looking at what happens before someone goes to trial on serious charges. The government, so this was referred to the commission by the government, by the Attorney General, and we were asked, should the committals process be abolished? Or should it be reformed in some way? Or should it stay the same? Now, this is something that all around the world, the different legal systems have been looking at. In the UK, committals were abolished a number of years ago. In New South Wales, I've recently made major changes to their pre-trial processes, including abolishing the committal. They still have other pre-trial processes. So this is something that a lot of systems around the world have been looking at, and certainly in Australia. So Victoria was just doing what is happening in other parts of the world. And the main reason why the government wanted us to look at this was to try to reduce the trauma of victims and witnesses. Now, this is something that happens, especially in something like sex offences. A person who has been the victim of a crime may have to give evidence, and they may have to give evidence not just in the trial itself, but they may have to give evidence in the pre-trial proceedings as well, in those hearings, at the committals hearings. In other words, they may have to give evidence several times. And if it's traumatic to do it once, it's even more traumatic to do it more than once. So that was one reason why we were looking at committals, was to find out, okay, is there a way of making this less traumatic for victims and witnesses? Another reason why we were looking at the process was to potentially improve the efficiency of the whole process, because this can take a long time. It can take a long time to get someone to trial. There are a number of hearings that have to happen. There are lots of different people are involved. People are coming and going to court a lot just before you even get anywhere near the trial. So we were asked to look at the process and see, is there a way of making it more efficient? But then The other thing, of course, that we had to do was, okay, if you're going to make changes, you have to make sure that it's still fair. We've got to guarantee that an accused person gets a fair trial. And part of the whole reason why committals existed in the first place was to make sure that the trial was fair, that you couldn't just send someone up to trial without any evidence. You know, that's not fair. So one of the reasons why we have committals is to actually test that evidence and to check that that really is a legitimate case before you send someone up to, you know, the Supreme Court and put them on trial for murder. You've got to actually demonstrate that there is a strong case. So we went out and we did a lot of consultations and we received a lot of submissions. And for an inquiry like this, of course, a lot of the people that we were consulting with were people within the legal system. So the courts, the police, the legal profession, people who are involved in trials, but also people who've been victims of crime and people who've experienced this process in different ways. And it was a really interesting inquiry, and this may be something that you might like to discuss in class, is, well, what are the benefits of having committals and pretrial processes, and what are the arguments against? The arguments in favour, and we heard this very strongly from a lot of people, is that, yeah, you actually need all those pretrial processes. You need the committal, because the committal is a process by which the magistrate decides, yes, there's a strong case here to send this person off for trial, and you shouldn't get rid of that. The pretrial processes are where the accused person finds out what is the case against them, what is the evidence against them, does the evidence really stack up? And part of that is cross-examining witnesses and saying, well, hang on, you know, is this actually accurate? What you're saying is this witness really a strong witness? If this goes to trial, is this witness going to be going to give evidence that is likely to convict this person, or does their story have holes in it? And sometimes when you go through that process, you may find out, well, actually, no, there's not a strong case here. And so maybe the person ends up not being sent up for trial, or maybe the charges that they've been charged with should be reduced to something which is less serious. And maybe the defense and the prosecution can decide that and resolve it without even needing to have a trial at all. So matters can sometimes resolve early. So those are strong reasons why some people argued that committals and the committal process needs to be retained. On the other hand, other people said, no, look, this process is too long. It's too complicated. There are too many hearings. It's distressing. It's stressful for everybody. Victims and witnesses have to go and give evidence multiple times. And a lot of the time, the defense is just trying to probe, trying to go on what's called a fishing expedition, trying to find a hole in the story, trying to find something which will stop the case going to trial when actually there's not a good reason for it. And all of this, of course, is expensive. You know, it takes ages and it's expensive. So those are some of the reasons why people said, no, we need to either abolish or at least reform this system. So we published a consultation paper. We received 27 submissions. And we conducted 38 formal consultations. And what did we end up recommending? Well, we ended up recommending that the committal should be abolished. We said we don't actually need that stage anymore. That's the actual decision where the magistrate has to decide, yes, okay, there's strong evidence here to send this person up to trial. We said that stage could be abolished. But we did say that other parts of the pretrial process need to be kept. So we still need hearings where you actually find out what the evidence is. You know, the person who's on trial needs to know what is the evidence against them. And they need to have some opportunity to test it. But we said the number of hearings should be reduced. At the minute, there are just too many. We also said there should be more protection for victims and witnesses from being cross-examined multiple times. There are rules about what kind of questions can be asked. There are rules about who can be asked questions, especially in sex offences, and especially relating to people like child witnesses or witnesses who have a cognitive impairment. There's more protection for those witnesses. And we said those rules need to be followed and strengthened. but we did make recommendations which would, we think, make the process quicker and more efficient and a bit better for victims and witnesses. So that report was tabled in Parliament. Now, the entire report is on our website. So I've only given you a very quick overview today, but I know that some classes are studying committals, and it's a good, interesting report to study. Go to our website, you'll find the whole report and all the information about it. Those recommendations have not so far been implemented. The response is for the government to decide. But the government did say that it was committed to implementing reforms to improve the committal and indictable pre-trial process in line with the policy intent of the VLRC's recommendations. We can sort of pore over those words and, well, does that mean they agree with us or not? Well, you can't really tell at the minute, but we will find out in due course. So I'm going to conclude by recommending that you might like to listen to our podcast, which is called Old Law, New Law. And you can find it on our website, or you can also find it on Podbean. There's the URL. And there is an episode in which we discuss committals. There are also episodes where we discuss sexual offences, inclusive juries, contempt of court. There's a number of episodes about different inquiries that we've done. You can go to our website for a whole lot more. You can follow us on social media. And if we've got a little bit of time, I think, for questions now, which I'm quite happy to take, but I would also say that if anybody, teacher or student, has further questions, you are more than welcome to email me at that email address, and I will do my best to answer your questions. So thank you for listening. And do we have a minute or two for questions, perhaps?
We certainly do. Thank you so much, Nick. That was fascinating. I know a bit about the VLRC, having been on it for a short period of time, but I always learn new stuff, especially about your current inquiries. We've got one question that's come in, and feel free, people, if you would like to add to our list, just use the Q&A function to do that. It's an interesting question about tabling in Parliament. What is it, and is it worthwhile knowing for legal studies? So I suppose, I mean, you can pick this up, Nick, in terms of what the process is about tabling the VLRC reports in Parliament. What happens, and why is that an important step?
It's an important step because that's the point at which it becomes an official parliamentary document. At that point, all the members of Parliament can read it, and we can publish it. And by being a parliamentary document, it gives us certain protections. But probably the most significant effect for us is it means that at that point we can publish the report. And it's a remarkably undramatic moment in the life of a document where, in parliamentary proceedings at the start of the session, they have a time when, usually round about before question time or after question time, can't quite remember, where they say, oh, we've got these parliamentary documents, we've got all these reports that we've received from different bodies, and one of them is this report on contempt of court by the VLRC, and it takes about like half a second for them to do that. And we sometimes watch the proceedings live and go, oh, was that it?
Yes, did we miss it?
Yeah, we did a year of work and oh, it's just been tabled.
Yeah.
But of course, but then that's just the formal moment. What then happens is that it goes off and the government, then will start the process of perhaps drafting legislation or asking government departments to do further work. And after that, the whole process just, creaks along.
Yes. It's really important, I think, because it is the moment of transparency. It's where all your work suddenly, is available to the public. And so it becomes a sort of democratic mechanism, if you like, of making sure that that everybody gets to see the work that you've been doing, and also then to watch and wait as to how the government will respond.
Yeah, exactly. Yeah, that's the moment at which it becomes a public document. Yeah, so it's an important part of the process.
Another question about the VLRC and whether or not you're likely to get a referral about how to reduce the COVID backlog in the courts. I mean, I think whether or not there's legislation around that is the key question. Would that be at the heart of that? There isn't. It's really more about process than it is about law. I would have thought.
I don't think that's necessarily something that we would be likely to get a reference about. I certainly haven't heard any suggestion that we would. I mean, one thing about the VLRC is, of course, it does take us time. You know, we look at things in great depth. We always need at least 12 months or 18 months to make our recommendations. And so if the government wants to act really quickly on something, then, well, they might not refer it to the VLRC because we're going to say, well, we need a year to do it. So with COVID, they probably want to act a bit more quickly than that.
Yes, there's certainly some real issues to be addressed. This is a really useful question, I think, Nick. So when preparing your recommendations, how much do you consider about whether Parliament will implement them? I.e., do you make some adjustments or water them down in any way? Are you mindful of how this will be received and whether or not you'll see an implementation?
No. I mean, our job is to provide independent recommendations of what needs to happen as a result of looking at the law, looking at the current situation and listening to the community. It's not really our job to sort of think about political expediency or those kind of issues. Sometimes we might make recommendations which we know are going to cause significant expense. For example, we may know that the government is actually going to be, any government might be looking very hard at something that is going to cost millions of dollars. But if that's what needs to be recommended, then that's what we will recommend. That's what being an independent body means, I think. It's, you know, we can let the politicians argue about that. Our job is to make recommendations about what will be good law and good for the community.
I'm just trying to quickly pick up another question. Could you outline what distinguishes or determines whether a matter goes to the VLRC rather than a parliamentary committee or a royal commission? Because those are other avenues for looking at law, aren't they?
Yes. Well, that is sort of partly a political process, really. It's whether the Attorney General decides that the VLRC would be the most appropriate body. You know, I really can't say what are the factors that go into making that decision. Sometimes it's, you know, it's to do with political calculations. Sometimes it's to do with how long it's going to take. Yeah. Sometimes things are so serious, so major that a royal commission is the best way to approach it.
We might have to get the Attorney General on to respond to that one in due course. And just one question about the study design, and I'm not sure how familiar you are with it, Nick, but is it important to know all the steps of recommending and reforming law? So your recommendations and then what happens in terms of the process to change law?
It's important. Yes, it's important to know all the steps. I mean, I certainly am familiar with the study design. I'm also familiar with the examiners' reports, which they publish after VCE every year. And I've seen examiners' reports that say students need to know every step, not just the start and the finish, but every step.
I've just got one final question just that struck me as you were presenting, which was really around the relationship between the committal's inquiry and the major report that you referred to that is coming down very soon on improving the response to sexual offences. There's a nice overlap there. As you mentioned with committals, the trauma involved in giving evidence several times can be particularly challenging for people who are victim survivors of sexual offences. Does that often happen, that you get a couple of inquiries over time that have intersecting sort of consultations or areas of law?
Yes, it certainly does. And that, I think, is one of the benefits of having a permanent body like the VLRC, because it means that we can be given inquiries which relate to each other. I mean, we've done a number of inquiries now related to victims of crime, and we've done a number of inquiries in particular about how people are treated, how victim witnesses are treated, and part of the sex offences inquiry, yes, is to do with how people are treated in court. You know, I mean, clearly that's a major problem in terms of sex offences being dealt with by the courts, is that if people who are the victims of sex crimes find the whole process of giving evidence very traumatic, as they do, then people are going to be very reluctant to go to court to press charges in the first place. And if that happens to them during the committal process, then they're going to be reluctant to go to the next stage of the trial. So all of these things are related. And I think it's one of the benefits of having a permanent body is that we build up expertise in these areas, and we can look at them in detail, not just in one inquiry, but in more than one inquiry.
Yes, from different points of view. I've got one final question, and I'm really going to rush this one in, Nick, because I know that we need a short break before we speak to David. But was the main recommendation around the neighbourhood tree disputes inquiry that people can now go to VCAT to resolve those issues? Is that what happened?
That was basically it, yes. We said, yeah, you can go to VCAT. And I think we said that there should be some, VCAT should have some, a particular area, particular people who are expert in that area to deal with those kind of disputes. At the moment, it's you can't go to VCAT. It's very unclear actually where you're supposed to go if you've got a tree dispute. This was not implemented though.
Yes.
The government did say that they were going to implement the recommendations in the tree disputes inquiry, but it's not happened as yet.
We wait and watch with interest. Nick, always a pleasure to have you. Thank you so much for joining us. And we'll take a short break now and return with David Thomson, who will fill us in on exam prep and study tips. Nick Gadd from the VLRC. We'll catch you again soon.
Thanks, it's been a pleasure.
Okay, I think we will get to our second session, which I know is of really great interest to so many of you in terms of preparing as best you can for the exams to come. Our next speaker is David Thomson. And I know, and maybe many of you do already, that he'll give you some really critical insights into maximising your time and effort. David has been a pioneer of legal studies in secondary schools in Victoria. He taught the subject 40 years. He retired from Caulfield Grammar at the end of 2016, but continues to be a really valued teacher in residence for us, and also at Victoria University, where he's a fellow at the Sir Zelman Cowen Centre. So highly regarded and deeply experienced. In 2018, he was awarded the Medal of the Order of Australia for his services to education. So I think that gives you some indication of his very deep commitment. We will once again have a little Q&A session at the end of David's presentation. Without further ado, David Thomson, lovely to see you this morning.
Thank you, Lynn. It's nice to be with all of you. I am going to borrow the motto of the Boy Scouts, and that is be prepared. And what I plan to do is to take you through some steps by which you can be prepared for the exam that will come at the end of the year. Now, 2 documents have been sent, or links to 2 documents have been sent to each of you, all of those people who have registered for this morning's session. And those 2 documents are, and I'll hold them up. The first one is this one called Maximising Your Performance. And I have a little confession to make about this one. When I reviewed it for it to be sent to you, I omitted to put back into it the pieces that were taken out of the study design for 2020. You may not know this, but last year, some pieces were taken out in order to reduce the complexity of the course, the volume of the course, because of COVID. Now, they have in fact been put back in, but they were omitted, and it's entirely my fault. They were omitted from the documents that's been sent out to you, and they will be put back in, and a copy of that will be sent to you shortly. The other document, the link to which has been sent to you, is this one, which is called The Australian People and the Constitution. And I'm going to make reference to both of those documents as we proceed during the course of the morning. One of the things that I want you all to do, and many of you may have already done it, is to get a hold of a copy of the study design, the units 3 and 4 study design. It's important to have that because it's your revision guide. If you tick off using the study design, and in the document that you will receive, there is a key knowledge audit that you can use. If you tick off each of the topics in units 3 and 4, tick them to say, yes, I'm on top of that, I know all about that, I'm fine, or cross beside it, perhaps to say, oh, no, I don't know all of that, I need to go back, and that becomes part of my revision. It's important that you look at all of those bits. It's very, very important that you don't choose your favorite bits and leave the others out, because you might find that the ones that you haven't followed through are the ones which turn up on the exam. So the study design is your revision guide. That's the first point I want to make. That's the first step to be prepared. The second thing I want you to obtain, and many of you likewise may have obtained it, is a copy of the Commonwealth of Australia Constitution Act. Now, don't go into a state of shock and horror and think, oh, we have to look at the whole of the thing. You need to have a look through it, because you've studied during the course of the year a number of sections of the Constitution. You'll understand those sections much more clearly and much more fully if you see how they relate to the whole document. In other words, if you see them in context. The context is important. So if you have a copy of the Commonwealth of Australia Constitution Act, you don't have to go and buy a hard copy. You can download it. Just Google Commonwealth of Australia Constitution or the Constitution and print it off and have a good look at it. But it will help you understand the bits that you've studied in some depth. And I'm going to have a look at some of those right now. During the course of the year, you've probably looked at sections 7 and 24. Now, those 2 sections look at the structure of Parliament, the election of members of both houses. Now, there's a case in your documents from 1992, which is called Australian Capital Television and the Commonwealth. Now, that case, in that case, the High Court created the only implied right that the court has actually found in the Constitution. And that's the implied right to the freedom of political communication. And since 1992, there's been a whole heap of cases, some of which are in the document that's been sent to you, relating to that implied freedom. Quite a few of which have sort of whittled it back a bit, have reduced the range of situations in which the implied freedom of political communication can be argued as a defence in a range of matters. Right up until a few weeks ago, in a case called Price and Spoor, SPOOR, Justice Stewart, one of the new judges on the High Court, made the assertion that he wasn't sure whether it even existed, the freedom of political communication. Now, that was in a judgment. It didn't form part of the whole determination of the case. But in the document that you've been sent, you'll find some cases relating to that. And study design requires you to do that. It requires you to be able to look at section 7 and 24 and make some observations about how those two sections relate to matters that have been decided by the courts. Section 109, you've all looked at that, I'm absolutely certain. Section 109 deals with the situation that may result when laws conflict, or that will result when laws conflict. And here we're talking only about laws where both parliaments can make laws on that topic. For example, taxation. Now, the Commonwealth can make laws on taxation because the Constitution says so, but it's not an exclusive power of the Commonwealth. It's one that's shared with the states. However, Section 109 protects the Commonwealth because if a state decides to make a law which conflicts with a Commonwealth law on taxation, Section 109 determines that the Commonwealth law will prevail. And you might have a look in the document that I've sent out at the uniform tax case. That really decide that, or you'll find it in other, it's in your textbook almost certainly. Sections 51 and 52, these set out in 51 the concurrent powers of the Parliament, and section 52 some reserved powers. So there's some exclusive powers of the Parliament. Powers can only be exercised by the Commonwealth. Most of the powers in 51 can be exercised by both the Commonwealth and the states. And of course, there we've got 109 as the get out clause if we need it. Section 92 just had a bit of airplay recently in regard to Clive Palmer and Western Australia, the freedom of interstate trade. That's an express right. It says there shall be freedom of interstate trade. Section 128, you're expected to know how that section, which deals with a referendum proposal, or which allows a referendum proposal to bring about changes to the wording of the Constitution. And during the course of the year, oh, I'm sorry, that's my clock going tick, tick for 11 o'clock. The section 128, the 1967 referendum with regard to Aborigines is a very, very good example to use. It's one of the few successful referenda that have been held since Federation. Section 51(29), that's what those XXIX means, 29. That deals with external affairs. The case to look at there, which is also in the documents, is Kuata and Bjelke-Petersen. It looks at the way in which the external affairs power can make use of external treaties. We entered into a treaty with the United Nations, a convention of the United Nations on eliminating all forms of racial discrimination. And in Kuata and Bjelke-Petersen, it explains how that prevailed. And it prevailed over contrary state provisions. In section 96, you might also have had a look at. There's a lovely old case from 1926 called the Rhodes case, which deals with a tide grant. Victoria wanted some money to build a road. in a particular location. And the Commonwealth said, yes, we'll give you a heap of money to build that road. Now, Victoria said, thanks very much for the money, but we're not going to build the road there. We're going to build it somewhere else. And the Commonwealth said, you can't do that. And so off they went to the High Court. And the High Court ruled that because of Section 96, if the Commonwealth gives money to states for a particular project, it must be used only for that particular project. Can't be used for something else. So if it's given for a particular road in a particular place, that's where it's got to be built. Now, you may have looked at some other sections of the Constitution, but those are the ones that are fairly important, and they're the ones that can crop up in exam questions. So it's a good idea to have a look at those. And there are cases relevant to those in that document called the Australian People of the Constitution, Australian People and the Constitution, which has been sent to you. It's important that you make, if we could lose that slide, please, Helen. No, we won't go on to that one yet. Can you pop me back? No, that's all right, don't worry. What we need to do is make sure that our topic notes are up to date. Again, this is where the study design can be very, very helpful. Go back through your notes, whether they're on paper or whether they're on computer, and ensure that you have notes that are complete in relation to each of the topics that you studied throughout Unit 3 and throughout Unit 4. There's no sense looking to see that they're up to date when you come to the last week in October. You need to have your topic notes up to date, and the best of you will have kept them up to date, will have made them up to date right from the moment you were looking at particular topics. But if they're not up to date, it's not too late. It's not too late. Make sure that your topic notes are current, that you have the information that you need on each topic so that you can use that for revision rather than having to start creating topic notes. Really important that. That's part of be prepared. The next slide, please, Helen. Over the course of the year, you will have looked at a number of cases. I want to introduce you to FIDS. This is the way I made case notes when I was studying law a long time ago, last century. FIDS allows you to make notes about the facts of a case. In other words, what happened, who did what to whom for a case to come to court. The I stands for issues. What did the court have to unravel? What did the court have to look at, have to determine in order to reach a decision? D obviously stands for decision. Who won? Who won the case? And the significance is, what significance does this case have? In other words, why on earth are we studying this particular case? Has it altered the law? Has it created new law where no law existed before? Has it interpreted a statute, which in turn might make new law or would make new law? When you're looking at a case, on the right there, you'll see a template, and you can use that template to write up case notes. And again, you can go back and look at the cases you've studied during the course of the year and pop them into a template like that so that you have clear notes on the facts, the issues, the decision, and the significance. The study design also requires you to observe fairness, equality, and access in relation to the cases that you've looked at. How does that case promote fairness? How has it resulted in fairness? Have the parties been treated fairly and all of that? We'll look at an actual example in a minute. Equality. Have people been treated equally? The plaintiff, the defendant? Have they been given a fair chance? And thirdly, access. Have they been given the opportunity to have the matter dealt with where it should be dealt with? Or has access been denied for a number of reasons? Perhaps they couldn't go to court because they couldn't afford it. Those sorts of issues come under the question of access. They're things we strive for. They're the principles of justice: fairness, equality, and access. And you're probably fed up with hearing those three words throughout the course of the year. because you'll have heard them a lot. Now, the next couple of slides are going to be fairly dense, to borrow one of Nick's words. A lot of detail, and I'm not going to read them all, but you'll be able to have a look at these slides because these are going to be sent to you. Could we have the next slide, please, Helen? The first of these cases you may be very familiar with. Wilson and Bauer Media, 2017, is the case that Rebel Wilson, the actress, brought against Bauer Media, the publishers of certain magazines. She claimed that she'd been defamed, and we'll have a look at that case in a minute. And the other one is one of my favorite old cases, Grace and Fraser. It's not all that old, 1982, but it's very useful. It's a significant case. When we look at it, you'll be perhaps really surprised that it is significant, but it is. It's significant to you, the students, because you can use it in a number of different ways. Could we pop up the details of Wilson and Bauer Media, please, Helen? Now, as I said, there's a lot of stuff there. I've really summarized the first bit for you, the facts. A series of articles published in magazines, gossip magazines. These caught the attention of media in America, and the actress, Rebel Wilson, claimed that they had harmed her ability to get work. She claimed that the articles led her to losing leading and lucrative film roles, as the slide tells us, and as a result, she suffered a degree of illness brought about by the stress over these defamatory statements. Now, the issues were whether or not the articles were defamatory. The court had to decide whether or not they were defamatory as a fact. They had to decide, did they actually refer to the plaintiff? Did they clearly refer to Rebel Wilson? And were the defamatory statements communicated to a third person? Now, when you looked at defamation, perhaps last year, you will be aware that those are the steps that you have to establish in order to be successful. A defamatory statement is one which is not true, and it's one which lowers the person about whom the article is written or the statement made, lowers that person in the eyes of the community. Now, the decision in this case was that the jury found for the plaintiff. The significance of it, it can be used for Unit 1 students, and it can be used by you in reference to the principles of justice. You could use it as a good example of the principle of justice in action. The fairness. There's a whole lot of stuff there about fairness. And again, you can have a look at the slide in depth when you get them. Both parties were represented by counsel. Both parties could afford the action and so on. Now, the court exists to resolve these matters. People, they had access to it. They had no great problem, equally represented. And of course, both parties could appeal. Now, as it turned out, it was Rebel Wilson who appealed, Bauer Media rather, who appealed, because they were pretty upset because the court, in the case that was brought first to the Victorian Supreme Court, Rebel Wilson won the case. The court said that yes, she had been defamed, and they awarded her the huge sum of $4.5 million. A lot of money. Now, Bauer Media appealed to the Court of Appeal. The Court of Appeal reduced the award of damages to $600,000. Now, Rebel Wilson wasn't very happy with that. She was thinking of terms, how can I spend $4.5 million? She was going to give a lot of it away too, by the way. But she wasn't happy with the reduction. So she sought leave to appeal to the High Court of Australia. The High Court refused to grant special leave, so she was stuck with the $600,000. But that shows the process of access to various steps that can be taken in order to achieve a result. Now, even though the significance of this case is in the first instance relevant to Units 1 and 2, it's also relevant if you are looking for a case to illustrate the principles of justice, a civil case. Could I have the next slide, please? Now, this is a terrific case. It's an odd one. In Grace and Fraser, a car is parked by its owner and driver who forgets to put the handbrake on. As she gets out of the car, goes into the city. While she's away, the vibration of other cars travelling along the roadway make her car move, and it rolls across the road and crashes into another car. She comes back and finds her car in an odd place, but she just gets in and drives away. Unbeknownst to her, a witness wrote down her registration number and a little note telling what happened and pinned it under the windscreen wiper of the car that her car had damaged. She gets a visit from a policeman, knock, knock, knock on her front door, and she is brought before the magistrate's court. She's charged under section 81E2 of the Motor Car Act for failing to report the full particulars of an accident on the basis that she was the person driving the motor car. Now, she went to the magistrate's court, was convicted, but she thought, hang on, was I actually driving the car at the time the accident occurred? Now, the issue was whether or not the words in the legislation, in the Motor Car Act, the person driving the motor car, should be interpreted narrowly so as to impose obligations only upon a person who actually had their warm grippers on the steering wheel at the time the accident occurred, or whether it should be interpreted broadly, as it had been by the magistrate. Now, the Supreme Court, Justice King in the Supreme Court, decided that it should be interpreted narrowly, quashed the conviction, and the driver of the car was acquitted. The Victorian Parliament thought, we're not happy with this, so they changed the legislation to make the person responsible for the motor car liable in such circumstances, which makes a fair degree of sense. Now, the significance of it, and I said before, there is significance in this case that because of an interesting thing about our exam, you can use an example in more than one answer. There's no rule that says you can't, if it's relevant. And this case is relevant in a number of areas. It's an illustration of a criminal matter heard in the magistrate's court. If you want an example of one of those to help one of your answers, you can use that. It's a simple criminal matter heard in the magistrate's court. Crash and bash, motor car case. It's also an example of an appeal on a point of law from the magistrate's court to the Supreme Court. So we're upping the ante of significance now. You can use the case as an example of a matter on a point of law, in other words, on what the law means or how it's applied, which goes on appeal from the magistrate's court to a judge, a single judge, one judge of the Supreme Court. So you can use it as an example of the relationship between courts within the hierarchy. And thirdly, significance, it can be used as an example of the relationship between courts and Parliament, because in this case, Parliament wasn't too chuffed about Justice King's decision. They couldn't overturn it in any other way. Well, I guess they could have appealed it, but they decided that the best way to do it, solve it all, change the act. So they changed the act to make the person responsible for the motor car that caused the accident. And such a person today, if you or I did the same thing today, we would have to put up with the fact that we've just been convicted under that amended section of the Motor Car Act. And on the right-hand side of this slide, again, we've got in information about fairness, equality, and access. And you can have a look at that when you have a look at the slides when those are forwarded to you. Now, I want to turn our attention to the exam itself. So if we could have the next slide, please. When it comes to answering examination questions, and it doesn't matter what subject we're talking about, for every examination, for every question in every examination, in the reading time, make sure that you follow these two questions, or you ask yourself these two questions. Now, just a few comments about the exam first. The paper consists of compulsory questions. Now, your teacher will provide you with information about the examination as it's released by the VCAA. There's been some shifts of dates and that sort of thing because of COVID. But you'll be kept up to date with all of that by your teacher. Now, as I said before, the examination paper is designed to assess a large portion of the study design. Do not omit any part of the course in your examination preparation. As indicated earlier, don't ignore difficult bits and don't specialise. There's a temptation, perhaps, to do a lot more reading in the bits that your pet bits, the bits that you think are really the fun bits. But don't do that. Make sure that you give the whole study design equal treatment. Read the questions carefully. That's what reading time is for. I've supervised a few exams over the years, actually rather a lot of exams over the years, and it distresses me when I see a candidate have an exam paper in front of them, they open it, have a quick look at it, then just sit back and relax for 14 minutes before the bell is rung to allow them to start writing. Don't do that. Use your reading time carefully. Now, you've been told that 1,000 times, no doubt. You can't write or mark the paper in any way during that time, but you can ask yourself these two questions that are on the screen. What's the content? In other words, what's the stuff I'm supposed to be writing about? And then, what's the task? What am I supposed to be doing with the stuff? Now, in the document that has been sent out, you'll find there's a page that sets out common task words used in exam questions. And you need to be aware of what those content tasks or common task words are actually asking you to do. If you're asked to analyze something, you're asked to make a critical examination of it. If you're asked to outline, you're asked to talk about it briefly. If you're asked to illustrate, then you're asked to use examples, or as many examples as the question asks you. If the question says, give one example, only give one, you get no brownie points for giving more than one example. If you're asked to justify, then you're asked to determine something by giving evidence, demonstrate something by giving evidence. If you're asked to what extent, you're asked to indicate the degree to which an intuition, a procedure, or a law fulfills a purpose or a principle. So what's the content? What's the stuff I'm supposed to be writing about? Secondly, what's the task? What am I supposed to be doing about it? Now, as far as the day of the examination is concerned, make sure you get to the examination centre a few minutes before the start time. Don't get there too early. You'll be a nervous wreck by the time you're called to go in. A few minutes is good enough, 5 minutes or so. As long as you're absolutely sure you're there in time for the start, but don't be there too early, and for heaven's sake, don't be too late. Bring enough pens, blue or black pens, and a ruler. Hang on, why a ruler? Well, because if you're going to cross something out, the best way, the favour you can do yourself is to cross it out neatly using a pen and a ruler. I said blue and black pens. I remember once trying to mark an exam paper that was written in yellow. Not good. In fact, the markers are entitled not to mark a paper. They're entitled to reject a paper if they can't read it. So don't try anything clever or funny. Blue pen, black pen. Cross something out with a single line. If it's got a line through it, the examiner knows that they're not to take the slightest bit of notice of what's written under that line. You do not have to obliterate the piece of paper. Nice, neat line is the best thing you can do. Allocate your writing time appropriately. Now, one of the questions that was asked by one of the registrants was, how much time should I spend for each mark? Now, the exam lasts for 2 hours. It's worth 80 marks. So a pretty crude sort of analysis of that is that you've got 1.5 minutes per mark. Now, you don't have to stick to that. You may find that you can answer short questions very quickly. You might have a 3-mark question, You may not need 4.5 minutes to answer it. Keep that spare time for the more complicated questions. I stress that that's a pretty crude analysis, 1.5 minutes per mark. It's not something that I would take a huge amount of note of. But what I'm really trying to say is don't waste time writing all you know about something when you're asked to do something which is fairly simple and straightforward. It's very important that you don't waste time. The exam paper is one in which you answer all questions on the paper itself. Do you have to fill every line? No, you don't. You may find, especially if you have small handwriting, that you leave a couple of spare lines and you think, I've answered this completely. I don't have to fill the rest of it up. No, you don't. If you have big loopy handwriting, you may need to use the lined page at the end of the paper and make sure you reference the question that you're answering there if you do. Now, something that the examiners don't tell you, should you need more paper, you can ask for a script book. I don't tell you that. I don't know why, but they don't. You are entitled to a script book if you need more paper than the exam paper provides. There's no rule that says you can't have a script book. Most of you probably won't need to. I'd be surprised if any of you do. But you are entitled to one, should it come to that. If there are numbers in questions, as I said before, if you're asked to provide one example, don't give two, as you don't get any extra marks. I referred to them as brownie points rather flippantly, but you don't get any extra marks if you use more than one example, if you're asked for one. Where to start? Wherever you wish, or where you feel most comfortable. My suggestion is start at the beginning and work your way through the paper. Now, you'll have a good idea of what the paper's all about at the end of your 15 minutes of reading time. But it's important, I think it's important, to start at the beginning and work your way through. Why? Because you're less likely to miss a question. You might gain time, as a short answer may not require extra time. Questions tend to require more detailed answers as you work your way through the paper, which means you can knock off the less detailed required responses earlier on. And certainly, answering the earlier ones, working your way through that, gives you a chance to warm up to the more the questions that require more detailed responses, more complex responses, which are the bigger ones towards the end of the paper. Don't leave the exam room early. You might want to take if you do finish early, let's say you finish 10 minutes before the end of the exam time. You could get up and walk out at that point. My advice is sit back, close your eyes, have a breather for a couple of minutes, then go back and flick through your exam paper and just check that you've written everything the way it's supposed to be written, the way you really intended to write. I know how difficult it is to proofread your own writing, but it's not a bad idea to try to do that if you have time at the end of the exam. You may not, but if you do, I would suggest stay till the end, review what you've written, become your own proofreader just for those few minutes, and you might pick up a word or two that is contrary to what you intended to write. I've done that sometimes. I know what it's like. Now, I was asked some questions by some of the people who registered for the webinar today. And I'm just looking for where I've written them down. The first one was costs. How do we get around this vexed question of going to law costing a lot of money? I have to admit, obviously, that it's very expensive. Taking a matter to court is an expensive business. But Victoria Legal Aid in regard to criminal matters and some other matters does help. Some work is done by solicitors pro bono and barristers pro bono. That is, they don't charge. That's not all that well known, but most solicitors and barristers do pro bono work, some pro bono work as a percentage of their ordinary work. They'll do that in situations where it's necessary to be seen to be compassionate. The government, in fact, requires lawyers to do some pro bono work if they're going to do work for government. It's an expensive business, but we want a top system. We want the best legal system that we can have. Best systems cost money. So money is going to come from users, the user pays principle, from legal aid, and from other support services. No simple answer. Can't sort of suddenly make it free for everybody, otherwise it ain't going to work. Introductions. I was asked, are introductions to exam answers needed? Short answer, no, they're not. Conclusions, a slightly different matter. If you're answering an extended response question, you might want to finish off with a final statement that positions you very clearly with regard to your response to that question. But introductions, no. It's not a piece of creative writing, it's not an essay. You go straight to the, you pardon me, you go straight to the guts of the issue and you deal with it in that way. I was also asked a question about drugs, about injecting rooms. Now, this is my personal view. My understanding, my feeling is that such services are provided as a balance, as an attempt to balance. It's a difficult balance. I'm not sure that it does balance, but it's to balance criminal law against saving people's lives. And as a community, we obviously have an interest in both aspects. We want to protect the community, but at the same time, if we can save people's lives, we will. Now, I hope this has been useful to you. I really enjoyed listening to Nick earlier, and certainly the example that he gave of committals is a very good example that you can use. I learned a lot from Nick's presentation this morning. Now, I just want to finish by wishing you all the very, very best for your exam. If we can help you in any way, don't forget you can get in touch with the Law Foundation and we will respond to any questions that you might have. Thank you very, very much and good morning.
David, can I hold you for just 2 more minutes because we've got a few more questions?
Yes, certainly.
Specifically about, writing the exam, which I thought a lot of people would be interested in. So when you made the comments earlier about, neatness on the paper, not using yellow pen, I can't imagine how difficult it would be to try and examine, to read somebody's yellow writing. It would be really hard. So there are a few questions about that process. One about whether or not, or how you add more information to a question after having finished it in a neat way. So how you reference, to another paragraph, for example, that you write in your spare pages at the back and make sure that the examiner understands where you're going, if you like, and what to add into their reading.
Well, what I would recommend is putting a big asterisk at the end of your response and then write C end pages, and then at the end, make sure that you put another asterisk and put the number of the question that you're writing an extended response to, so that it's perfectly clear to the person who's marking the paper that there is more to come at the end of the paper to that particular question. If it's question 6, let's say, you've got an asterisk, C end pages, you go to the end page, and then there's an asterisk, question 6 continued, and there is the extra paragraph that you want the examiners to include.
Yeah, that makes very good sense. And another question about, how there's space without lines at the bottom of the examination papers. Can you fill that as well, or should you only use the paper that's lined?
I can't see any particular reason why you can't use the blank paper, as long as it's the question that sits at the bottom of the paper and you're just writing a couple of lines below that. But if it's going to extend beyond that, then don't do that. Use the end pages. And as I said before, if push really comes to shove, then put your hand up, say, please, can I have a script book? And they'll sort of all go, ooh, and they'll get you one because they have to. Good.
What about 10-mark questions, David? Somebody's asked for advice on the 10-mark question. Is there any sort of, I suppose it depends on the instruction and what the task is, but any quick top of mind thoughts on that?
Well, exactly. It does depend on what content you're expected to deal with and what you're asked to do. A 10-mark question is going to be one that clearly requires an extended response. It's going to require you to be analytical, or it's going to require you to look at a series of steps that need to be taken to achieve a particular objective. For example, if it were a question on law reform, going back to Nick's presentation, then you would be expected to be able to include in a 10-mark question a pretty fair coverage of the steps by which an issue is dealt with. So you might use the committal proceeding recommendation of or at least the reference of the Law Reform Commission, and you'd be expected to provide a fair amount of detail. But again, it comes back to what's the content, what's the task. And there you are expected to provide a fair amount of what you know on that particular topic.
Well, that wraps us in terms of time, David, and I know that people will be enormously grateful for your advice thus far. And as you've said, we are happy to field any further questions, and people will get the materials that you referred to earlier. So thank you again for your advice and insight. And I think we all at the VLF would wish everyone who's sitting their legal studies paper at the end of the year every success. It's a fascinating area of study. I hope you've enjoyed the last couple of years, and that you do exceptionally well when the time comes to sit in the room and write the paper. David, a pleasure as always to see you. Thank you everyone for your attention. We will send the slides and all the materials, and we'll look forward to catching you again at the next online Law Talks.